Hello everyone, and welcome to Ibec's webinar on transfers of personal data from Ireland to the UK in the event of no-deal Brexit. I'm joined today by my colleague Nicola Coogan with the Data Protection Commission, who have kindly partnered with us on this initiative. And the format for today's webinar is we'll briefly go off screen and I will give you an economic context to this issue. Then Nicola, my colleague here, will give us a presentation on the impacts of a no-deal Brexit on data transfers. And then after that, we'll do a brief Q&A on most commonly asked questions with regards to this issue. So the first thing is the economic context. Ibec, for its part, actually sees digital and data as being a competitiveness issue for Ireland. The digitally intensive sector in Ireland roughly employs 10% of the workforce, and it adds around 30 billion GVA to the economy and accounts for about 26% of the exports. According to the EU, approximately 30% of our SMEs sell online, and 17% of those SMEs, or 17% of our SMEs, sell online and cross-border. That's first in Europe. So therefore, the idea of cross-border data transfers is going to be very, very important. In addition, 9 out of 10 business leaders, both large multinationals and also SMEs, believe that data protection is a major business issue. Importantly, so do our customers. 9 out of 10 of our EU citizens, this is a Eurobarometer report, 2015, actually believe it is important to retain data rights and protections regardless of the country the service provider is established. Helen Dixon, the Data Protection Commission for Ireland, is actually on record as saying we're all data companies now. So this is a very, very important issue. And in that context, this is a very, very timely webinar. To find some of the relevant information in what I've talked about there, Ibec has produced guidance on no-deal Brexit scenario and data transfers, and we have information on GDPR advice and our digital policy work at ibec.ie/digital economy, where you can look up some of this information. Now, without further ado, I'm just going to hand over to my colleague, Nicola, who's going to take us through the issue.
Thank you, Eric. Yes, as you've already identified, the flow of personal data out of Ireland to anywhere is a major issue for companies, and in the event of a no-deal Brexit, it becomes even more important because a huge number of Irish companies deal with the UK, and at the moment, free movement of personal data is guaranteed between EU member states, so there's no issue with transferring data to the UK, including Northern Ireland. But once the UK leaves the EU, and in the event of a no-deal Brexit, that could be as soon as the 29th of March, the UK will become a third country, and therefore transfers to the UK would be the same as any of the other countries outside the EU, such as the United States, Brazil, China, and Irish companies will need to put in place something else to legitimise that transfer. It will have repercussions of all organisations and bodies doing any kind of business with entities in the UK and Northern Ireland if personal data is being transferred. Legal safeguards will have to be put in place by the Irish-based organisation or bodies that are transferring the data. And those safeguards are laid down in the GDPR, and we have guidance on our website, and the European Commission and the European Data Protection Board websites also have guidance. But just to quickly go through the safeguards that might permit the transfers of the data. One of the most commonly used safeguards are standard contractual clauses. These are contracts, model contracts, if you will, that the EU Commission have developed, and there are 3 different types that can be used for contractor to, or controller to controller, or controller to processor. These are quite an easy safeguard to put in place because it just means adding the clauses to the contract you will already have in place with your UK-based processor or the controllers in the UK that you're transferring to. There is a further version of those clauses called ad hoc contractual clauses, whereby you might need to change the content of some of the clauses because the standard don't meet your requirements. This is not really an immediately available tool because it requires both the approval of the Data Protection Authority, so it'll be ourselves, and also the European Data Protection Board. So it will take a number of months to actually get ad hoc clauses approved. Binding corporate rules is a tool that's usually used by large multinationals, which allows them to transfer data within the corporate group. Once they are approved, they take a number of months, if not a year or more, to get approval. So again, they're not immediate tools. They're also not suitable really for small and medium enterprises. They're very expensive to get put in place, and they may not be suitable for an enterprise that might only have maybe 2 entities involved. It would be huge costly exercise that would be a bit of an overkill for such transfers. The GDPR also introduced some new possibilities for transfers under codes of conduct and certification. These are tools that are very much, the thought development for these tools is very much in its infancy, and we're not very sure how it will pan out as how they will be used as transfer tools, and obviously therefore they're not immediately available, but will be in the future. Guidance is coming out from the EDPB soon on codes of conduct and certification, but as a transfer tool they will not be available in the near future. And as my slides say, they're not suitable for all types of business either. So you have to look at your business, what type of transfers. If you're a very small company, SECs might be the most obvious tool that you could use. Another point to mention is an adequacy decision. This is where the Commission decides that a country ensures adequate levels of data protection when data is transferred there, and they already have made decisions on a number of countries such as Japan, New Zealand, Canada, and Israel, and a couple of others. But the UK does not have an adequacy decision as it stands, and it's not possible to start the approval process until they become a third country. If they had an adequacy decision, this means you wouldn't require these other safeguards. The flow of data could continue as it stands, but as it will not be forthcoming in the immediate or even medium term, it could take over a year. It's not on the table for people to consider that this will be in place for March, and therefore it's a safeguard will have to be put in place. As regards what businesses should be doing next, you need to check your data flows to see if personal data is transferring to the UK and Northern Ireland, and that you will continue that transfer post-Brexit. If you are, you need to put in a safeguard to legally transfer this data. So look at adding SEC to the contracts you already have in place, or look at some of the other methods for transferring data legally. You also need to notify your customers, your employees and your suppliers that their data has now been transferred to a third country if you haven't done so before. So your privacy policies or statements might need to be updated. Your employees' notifications might need to be updated, and that's something you should be putting in place now. Our website has a good bit of information on international transfers generally, and then specific notices about transfers in the event of a no-deal Brexit. The European Commission also has notices which are being updated regularly, so I would keep an eye on that website. And also the EDPB has recently put up a notice about transfers in the event of a no-deal Brexit, similar to our own guidance. So I would keep monitoring all 3 websites to see if there's any updates.
Nicola, thanks very much for that. That's excellent. What we might do now is just delve into some of the most common questions that we've been receiving from members. So maybe first off, I mean, would consent be suitable in a human resources context for Irish to UK data transfers post-Brexit?
Consent is one of what we call the derogations, so it is listed in the GDPR as a possible transfer tool, but in the case of a HR context, it would not be appropriate to rely on consent of the employees for a payroll scenario. First of all, because it's going to be a regular event, it could be weekly, fortnightly, monthly, it's going to be a regular event for the entirety of their employment with you. And derogations are supposed to be used in limited and non-repetitive scenarios. Also, the consent has to be explicitly given, and it has to be explicitly explained to the person, and it has to be freely given by the person. And in an employment context, the power is with the employer. So it may be argued that it's not necessarily freely given, and there is no power to object to or withdraw consent in such a scenario. The data has to go to that payroll supplier. So therefore, putting in place a contract would be more appropriate in that scenario.
Oh, I see. Another common one we've got is in intergroup scenarios. I mean, what circumstances do I need a standard contract clause as an employer for Irish to UK transfers?
If you're an Irish entity and you're part of a larger group and there is a UK entity and they're the person, for example, running your payroll, then you would need to have a clause in place for that scenario, standard contractual clauses. Or if you're using an outsourced payroll company within the UK, again, you would need standard contractual clauses. You might also be part of a group which has a binding corporate rules in place, and if that is the case, it's already there, already approved. You can continue transferring on the basis of those binding corporate rules, so long as the UK entity is still signed up to them also. There may be cases where the data is just going to an individual within the company. And in that case, it's a slightly different scenario. But in the main, if it's going to another legal entity, a standard contractual clause or some other legally binding instrument should be in place.
In a situation where they're the same legal entity, is a standard contract clause needed in that situation?
Well, if they're the same legal entity, so for example, if the Irish entity is just a branch of the UK main entity, and they're not a legally registered company in Ireland, then it's not possible to enter into a contract with yourself as such. So in that case, it may be the case that it's not actually a transfer because it's being kept within the one entity as such. But again, it would have to be looked at on a case-by-case basis to ensure that we can see what's happening with the transfer.
Yeah. You mentioned individuals there, in terms of that. I mean, where we have operations, say in the UK, and line reports directly to UK, for example, maybe a chief financial officer accessing data, do I need to do anything in that situation?
Again, there's a couple of different scenarios. So if the chief financial officer is just accessing the data to observe, for example, the payroll, or to observe what's happening within a payments area, so they're remotely accessing data on Irish servers, that may not constitute a transfer as meant by the GDPR, and mightn't necessarily require a tool. But if they're doing something and they're a separate legal entity, so you have a UK-based entity and an Irish-based entity of the same group, standard contractual clause would need to be in place. And certainly if they're processing the data or doing any further manipulation or running reports of Irish entities' employee data, then a legally binding method of transferring the data would have to be put in place.
Okay, that's clear. So just maybe another scenario, maybe a financial services type company who might be giving client financial information to a UK bank at the request of clients. How do they protect themselves?
In that scenario, it's kind of different, say, from the HR, where consent actually might come into play in this scenario. So what I would advise, if a Irish financial entity is gathering information and the customer is asking to pass on that information to the UK banks, I would advise that within their agreements with those customers that they do identify that this will occur and it's transferring to a third country, and seek the consent. So it's very explicit what they're agreeing to. That would, in that very limited scenario, because again, it would be a once-off, consent may be the appropriate derogation that can be applied here.
Great. How would it work if an Irish business sends over details of employees who have used a UK-based trainer and the trainer wishes to contact them directly?
If they're using the UK-based trainer, for example, on an ongoing basis, they would have to have standard contractual clauses in place with that trainer, and then the sharing of the data with the trainer would be covered. The contacting of the employees by the trainer is a different question, and I think might need to also require the consent of the employees. It depends on what they needed the contact for. If it was further to fulfil their contract as part of the training, then again it could be covered by one of the derogations or by the standard contractual clauses. If it was for marketing for purposes, for example, that would be a different scenario, and definitely would require the upfront consent of the employees. So it would have to be again on a case by case basis and looked at closely to see what's happening after the data transfers.
Okay. I mean, GDPR has been in it's been in since May last year, but to be GDPR compliant and Brexit proof, what do I need to do by 29th of March?
Well, to be GDPR compliant, you would already have your contracts in place with those suppliers that you're using in the UK. You would already have mapped your data flow, so you'll know where all your data is going and who is it going to, and you will already have privacy statements or privacy policies in place. So all of those will still be required. But in order then to legitimise transfers in a Brexit no-deal scenario, you will also need to put in SCCs or some other safeguards. So, for example, if you're using a UK provider for payroll, you already have a contract in place with those people. If you don't, you're not in compliance with the GDPR. So to supplement that contract, you can add SCCs as an appendix to that contract and ask them to sign those in addition to the contract you already hold. And that will Brexit proof, for want of a better phrase, the transfer in addition to the GDPR requirements.
Now, one final question. There's areas like certification and codes of conduct. There's guidance to come on that, I believe, yeah. Or is there's contract processor rules? Mm-hmm. Would you be able to give us an update on how that process is working and evolving?
Yes, as regards codes of conduct, guidance is coming out from the EDPB. It's due to be adopted next month, and then it will go out for public consultation for 6 weeks afterwards, from mid-March onwards. So I advise anyone that has an interest in a codes of conduct to engage with that public consultation, read the documentation and provide feedback if at all possible, because that will help to shape how codes of conduct will look for the future. Now, the transfers as part of a code of conduct is a very novel approach. It's only newly in the GDPR, and it's something that we will need to work further on. So there will be further guidance in specifically relation to transfers. And similarly with the certification, the transfers piece is separate to the main guidance on certification, and it's been worked on. It's at a very early stages, but I would, again, EDP guidance will be published, and it will also be published on our website once it's published by the EDPB. So it's something to keep a watch out, but it's not going to be an immediately available tool, but it is something that we're working on to see how we can best get those areas used by companies.
Nicola, thank you so much for that. That's very, very informative, and we'll certainly, as Ibec, be encouraging our members to reply to that certification and so on, those consultations as they arise. And we draw members and businesses' attention to the relevant website information that's mentioned in these presentations and in the webinar. And if members have questions, they can always come back directly to Ibec, as we're working with the Data Protection Commission in partnership to try and answer as many questions and help as many people as possible in this area. Nicola, thank you so much.
You're welcome.